for client families that own small businesses, and I find out pretty quickly in a conversation that a buy-sell is absent from their document list. I think it's a great opportunity not just to bring legal expertise to draft that document, but to also have a CPA and your financial advisor at the table. That sort of collaborative team approach to building that particular document is really, really wise. Two things within that document that I'm always sort of scanning for the second I get an opportunity to look at a draft or look at a ratified buy-sell agreement. One is whether or not the funding is adequate for fair market value of the entity. No matter how fair market value is established, if you don't have the proper insurance instrument to underwrite that particular document, you're in real trouble. And the surviving spouse, in the case of premature exit on the part of the owner, you're really putting both the entity at risk and you're putting your spouse at risk, especially if the wealth gap, the amount of illiquid versus liquid exposure in that business, is lopsided in the direction of the actual business entity. Furthermore, when I think about buy-sells, the other element in addition to funding that I'm looking for is that it would be written in such a way that the surviving spouse can actually understand its implications for them long-term as an individual, and then also for the family at large. If that is written in such a way, either because of the process itself or the document itself, that there's ambiguity about whether or not the unlikely event of your premature death happens, if there's ambiguity about whether or not the family is going to be okay, then you haven't done your job. I don't care how fancy the document was. I don't care how much you paid an hour for a really high-priced attorney. You have to have a real clear understanding in the hands of the surviving spouse. Otherwise, you really haven't served the purpose of a healthy buy-sell.